Good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace and I'll be the presiding judge today. I have joining me on this panel from the 5th District Court of Appeal, Judge Dan Traver from Orange County. And we also have the privilege this morning of having Circuit Judge in the 9th Circuit, Lisa Munyon, joining us. I want to thank Judge Munyon personally for helping us with our oral arguments today. And welcome. And we have one case on the docket this morning at the 9 o'clock slot. That is Ricardo, I will not butcher the middle name, Taylor, Mr. Taylor versus the state of Florida. And I will assume, Mr. McLean, that you would like 5 minutes of rebuttal unless you tell me differently. I would ask that the lawyers or everybody just please silence any noise-making devices that may interrupt the parties' arguments or the questions during the session. And other than that, Mr. McLean, you have the floor. You may proceed.
Thank you, Your Honor. Matthew McLean on behalf of the appellant Ricardo Taylor. I will be reserving the 5 minutes. Today we have two issues, one regarding ineffective assistive counsel, the other regarding a sentencing error. I'll start with the first issue regarding ineffective assistive counsel. According to the decision of Bryce, an attorney is responsible to give adequate representations about the chances of success at trial. In this case, the advice that was given by the defense attorney was, your case is arguable, but juries are unpredictable. And that's an exact paraphrase of exactly what the attorney told him. This case was anything but unpredictable. This case was not arguable. This was a slam dunk case for the state. They had identity proven for burglary. They had entry proven. The only issue was regarding intent. And in this situation, there was a stealthy entry instruction that was given and that the attorney was aware of during this plea offer. And the stealthy entry instruction was completely applicable. As the state argued on direct appeal, the evidence was overwhelming in support of that type of jury instruction. That jury instruction allowed the jury to presume that he had an intent to commit a crime because his entry into the residence was stealthy. And why was it stealthy? Clearly, when somebody strays from a sidewalk, strays from the front door, strays from an open garage, and tries to enter from a side area that is covered by bushes that cannot be seen by the street, that's the epitome of stealthy entry, and the presumption would be given to a jury under the circumstances. So instead of giving the advice, this is a arguable case, this is juries are unpredictable, it should have been, if you go to trial, you're likely going to lose. And the risk is great in this situation because
isn't that what the trial court told him in open court? I mean, not word for word, but I mean, the statement in open court was there's a factual basis to proceed. We just had a trial like this on similar facts and the defendant was found guilty.
Well, I don't think that the judge was aware of all the facts in the case and obviously wouldn't have been aware of the advice of the evidence is overwhelming against the defendant. So I don't think that the judge gave the adequate advice to say that there is evidence to prove this case. And I think the attorney, did say that there is evidence to prove your guilt, but he said it was arguable and juries are unpredictable. And in Bryce, the same situation occurred.
Which of those statements is false?
The fact that it's arguable and unpredictable, both are false.
The stealth jury instruction is just it's a presumption that is theoretically rebuttable. And I mean, we're not going to argue that juries are unpredictable, correct? I mean, that's solid advice.
I think that you have to give better advice under the situation that, it's really no advice, arguable and unpredictable. So Your Honor, you're correct that every case is arguable, every case is unpredictable in a sense, but there need to be additional advice in this situation that the state has overwhelming evidence of guilt. And how do you?
Mr. McLean, you're removing, I believe what you're trying to do is totally remove the human element of a jury trial entirely. So you're taking out of the consideration what jurors think, do, even when they're given clear instructions. So that's why you have closing argument. That's why you have lawyers have the opportunity to make those closing argument. You're asking us to totally remove that. If we do that here, then we're going to do that in every case. Where does that end? Where does that slippery slope end?
In cases where there's overwhelming evidence of guilt, had his attorney told him, look, there's overwhelming evidence of guilt. You're facing a 15-year mandatory PRR, 30-year VCC, up to 40 years in prison, and they're offering you 6.5 years. The advice needed to be this: they have overwhelming evidence of guilt. There's a huge risk of going to trial, and ultimately, then it's up to him to make the decision. But to go ahead and provide the advice that was done is deficient performance pursuant to Bryce, and argue that he was prejudiced in this case in passing up a 6.5-year offer.
Do you mind moving to your second issue?
Yes, I will. So regarding the second issue, Mr. Taylor was convicted of burglary, which is a second-degree felony punishable up to 15 years in prison. The state noticed in writing a VCC and a PRR notice. There was no written notice of habitual felony offender. To the extent that's not clear in my briefing, that is what happened in this case. The only mention of habitual felony offender status was during the plea offer, when the plea offer was 6.5 years as habitual felony offender, but no written notice was ever made. So he goes to sentencing, and originally he is sentenced to 15 years PRR with also a 30-year VCC. A motion to correct the legal sentence is filed because it seemed to be the judge misinterpreted his discretion in the case regarding the VCC sentence portion of it. At the motion to correct sentencing hearing, the court found a 30-year sentence is not necessary to protect the public, and instead of sentencing Mr. Taylor without regard to the VCC section as required by law, the court imposed an unauthorized sentence of 20 years as a VCC and 15 years PRR.
If the state had cross-appealed that particular decision during Mr. Taylor's direct appeal, do you agree that that we would have had to reverse for the imposition of the 30-year sentence at that time?
No, I do not. I think by the fact the court saying that it's not necessary for the protection of the public, the 30-year sentence, that takes away, and the court made a discretionary call. And when
so you read out the language in that order that still designates him as a VCC?
It still designates him as VCC. However, it made the finding that the only authorized sentence as a VCC, which would have been the 30 years to 40 years, was not necessary for the protection of the public.
How's this a situation that's any different than the Pope case out of the second DCA, where the trial court labeled the defendant a violent career criminal, but gave that defendant an illegal sentence?
I don't think it's any different than the Pope decision. I think Pope is very instructional in what this court should do in the situation. In Pope, the VCC statute in that case required a life sentence. Still labeled him VCC and gave him a 35-year sentence.
Right. So I'm not trying to be difficult. I think it's helpful to you, right? That if the state had actually exercised its right to cross appeal and his direct appeal of that judicial decision that he was a VCC but imposed an illegal sentence, wouldn't the state have won at that particular point in time?
I understand your point, Your Honor, but I think that the finding is still there. I know that the Pope decision did allude to that fact. Had the cross appeal been done, then the court would have had to impose a life sentence. I think this case might be factually different in the fact that he made the discretionary call that the 30-year sentence was not appropriate. I don't know what factual findings were made in Pope by the trial court to give the 35-year sentence, or if he was aware or made a finding regarding life is not necessary for protection of the public. But I think once this court entered its decision and made its decision that's not necessary for protection of public, VCC no longer applies, period. So I don't think even if the state had cross-appealed, it would have been successful. But it didn't, so we're not stuck with that problem. So in this situation, just like Pope, there's no cross-appeal by the state, even in this situation. So we look at Pope, the remedy that was provided was you can't resentence him as a VCC, that's gone. So now you're stuck with a first-degree felony, punishable to 30 years with a 25-year mandatory. So go ahead and resentence him pursuant to that range. It wasn't go ahead and have a de novo resentencing in which any other enhancement that theoretically could have been imposed can be imposed. In this situation, there really is no discretion on the part of the trial court. The only available sentence based off the sentencing is a 15-year PRR sentence. So at the VCC, if we put ourselves in the court's position at the time of sentencing, the state is asking for a VCC sentence or a PRR sentence. The court says VCC is not appropriate. So is
a resentencing going to be a de novo proceeding? Just is any resentencing going to be a de novo proceeding?
Yes, Fleming v. State makes it clear that a resentencing is de novo in nature.
So what if the state in the resentencing of your client fails to prove that he's PRR?
I think that finding is already there. So I don't think and that's the other problem is there is a lawful PRR sentence here. So we're not disputing.
Right, but doesn't the state in a de novo proceeding have to prove it again?
Yes, I guess theoretically they would in de novo proceeding. Yes, Your Honor.
So then what's to stop the state from trying to prove some other sentencing enhancement other than VCC?
The fact that there is a current lawful sentence there as a 15-year PRR, and that there was no HFO sought or no notice sought regarding.
I understand that there's a notice requirement, but if it's remanded for a de novo sentencing proceeding and the state gives proper notice, why can't the state present evidence of a different enhancement status in addition to PRR if they have to prove PRR already?
Well, I think, then you go ahead and enter into due process considerations, double jeopardy considerations. So
why would it be a double jeopardy violation if, say, and let's assume for a second that the original court's sentencing intent is honored. I'm not suggesting for a second that there's HFO and he gets more than the 20 years. Let's say that it's HFO and the original court sentencing intent gets honored and it's a 20-year HFO sentence and a 15-year PRR sentence. Where's the double jeopardy violation there?
I don't think under that situation there would be a double jeopardy violation. I think if it goes beyond the 20 years, that's when we'd be talking about a double jeopardy violation.
Do we even know that that's happened yet, though, until the lower court has its resentencing?
No, we don't know what's going to happen if the court is ordered to do resentencing. It would theoretically go before the judge who originally sentenced him. My understanding is that judge is retiring in January, so it probably would be a new judge. But I think the issue is, and maybe this is where the double jeopardy violation comes in, is how are you vacating? How can a lawful sentence be vacated, an otherwise lawful sentence be vacated? So it would be vacating a portion of a sentence, the 15-year PRR, to hold a de novo resentencing in toto.
Right, and if the state doesn't prove the 15-year PRR, then he doesn't have to go day for day anymore. Is that legally inaccurate?
No, at a de novo resentencing, if the state is not able to prove up a PRR sentence, then that would not qualify to de novo resentencing. They'd have to do that. But the point is that there's no dispute that he qualifies for PRR statute. And so if we put ourselves in the position of the court at the time of this sentencing proceeding, there's two sentencing enhancements on the table. And so it shouldn't be for any situation to go ahead and remand for a new sentencing so the state can somehow try to enhance the sentence a different way. And that's what happened in Pope too. It wasn't a remand for a de novo resentencing, the court specifically capped the trial court into 30 and 25 years, when theoretically, in Pope, that defendant would have also qualified for habitual felony offender based off of his qualifications as a VCC. So if we're following the precedent that's out there, I think the proper remedy is to remand for the imposition of the 15-year PRR and to strike the illegal portion of the 20-year VCC, because the court simply was mistaken that it had the ability to do anything other than just not impose a VCC sentence.
If we do actually accept your argument, what would be the point of a de novo sentencing if we are telling the trial court impose the sentence you've already imposed, that is the 15-year PRR?
And that's why we did the appeal of the remedy, because we don't think that a de novo resentencing is appropriate. We're not asking for a de novo resentencing. We're asking for the court to strike the 20-year VCC portion of the sentence and maintain the 15-year PRR sentence, which is the only sentence that can be given under the circumstances. I see that I'm at rebuttal time. If there's no further questions, I'll go ahead and reserve the remainder of my time.
Okay. All right, Mr. Corrente. You may proceed.
May it please the court, Carmen Corrente for the Attorney General's office in the state of Florida. We have a sentence that was a legal sentence when it was first imposed, and it was reduced with an illegal sentence to 20 years. It was the state's position, first of all, I mean, it's even in the language of the order, and it's very clear that the sentence in the instant case is reduced from 30 years as a violent career criminal to 20 years as a violent career criminal. So that's an illegal sentence. You have to do the 30-year. And it's the state's position that
appealed that particular issue on direct appeal, it would have been reinstituted as a 30-year sentence, correct?
yes, if we had raised it after the 3800 that was filed during that, it would have been reversed. At the same,
if we see this
for the
your
defense.
way, if we see this your way, at least the way that you asked for it in the briefs, and remand this for the imposition of a 30-year VCC sentence, do we have to certify conflict with the Pope case?
No, Your Honor, I don't believe so, because this is the only valid sentence that was imposed. The other one is an illegal sentence, and that's within a legal sentence.
In Pope, the only sentence that was imposed was an illegal VCC sentence. The trial court sentenced him to 35 years as opposed to the only permissible sentence, which was life. And then on appeal, now Justice Kennedy basically said, you've missed your opportunity by failing to cross appeal. Do I understand Pope correctly?
Yes, that's correct. But that was the only option available in Pope.
Well, why should it be any different on 3850 if the state didn't exercise its right to cross appeal on direct appeal?
Because that isn't the only other option. There's the intention of sentencing generally is to fulfill what the original judge wanted to do. If the judge wanted a 20-year sentence, it wasn't raised at that time because they were working on with a PRR and the VCC. If the 20-year sentence is what he wants to impose, then he can do it with an HFO. And in a new sentencing hearing, that can all be fleshed out. So that's why the state.
That's a different argument, though, than the reimposition of the 30 years. If your argument is that in the de novo resentencing hearing, the trial court can honor its original intent, then why isn't the sentence capped at 20?
This court could, I argued in the alternative. I believe that an illegal sentence is void ab initio, that it didn't reduce the sentence to 20 years, and that the only sentence that's there is the original sentence. It was merely reduced. It wasn't even set aside, and the judge didn't even find he's not a VCC. I just don't think he needs 30 years for a sentence to protect the public. 20 is fine, basically, I think, because of his age. But the state is arguing in the alternative. If that original sentence is not valid, and he could go back, and if he is sentenced to that, he has his appeal rights and he has his mitigation rights, and the judge can change it to an HO. At least the state should have the opportunity to say, if you want, and to offer to the court, if you want to do a 20-year sentence, it can be done with an HFO. Here's our notice. We will approach it that way.
And similarly speaking, would you agree with Mr. McLean that if the state fails to prove that he's PRR in the de novo resentencing proceeding, then the trial court doesn't necessarily have to sentence him PRR?
Correct. I agree. That's why one of the options I suggested would be send it back because the judge is either under a misconception that you can be VCC and still get 20 years, or give him the option to give that 20 years a different way if that's what he was focusing on and not VCC. You could do an original one, and I think that's what would happen if you sent it back with the 30-year that was originally imposed, because that sentence still has to be imposed by the lower court. So we don't have a real jurisdictional issue here as far as he hasn't been sentenced, technically, as far as I know, at least in this record. And so when a judge does that, the judge down below would have the benefit of this court's ruling as to what options were available. And so we would ask that it be sent back either of two ways, to the original sentence or for a new sentencing hearing, so that the original intent of the parties could be brought out. As to the first issue, the Bryce case, which the defense relies upon, states clearly that it's the defendant's assessment, that his counsel's assessment must be unreasonable. To say that this case was arguable is not an unreasonable statement. I don't think it's a overwhelming evidence case. They didn't think it below. They argued the stealth. They argued the intent throughout the entire trial. That was the trial, whether there was intent and whether there was stealthy entry. They argued it on appeal, which was brought to this court, where the only argument was there was no justification for the stealthy instruction. And this court affirmed. I don't believe that there have been any cases with just daylight, something in broad daylight with nothing else, that have actually authorized the instruction. And if it did, they found that it was harmless error because there wasn't any proof of it. You can argue to the jury, which this defendant did very well. Counsel argued to the jury that this isn't stealthy entry. This was barely entry. This was poking a head in at the most. It's not the same thing as being able to remove the bike, to reach in, or even to gain access. So we believe the evidence is clear that counsel's advice that say it's arguable and juries are unpredictable is not unreasonable, and certainly is not ineffective under the facts of this case. If there aren't any other questions, I would rely on my brief. Thank you.
You have a little less than 5 minutes.
May it please the court. Just briefly regarding the illegal sentence issue, the 30-year sentence that the state is asking to be, as one of the alternatives, reimposed, it doesn't exist anymore. It was vacated. It was not appealed by either party on direct appeal. It's a non-issue, I believe, in this case. The only sentence that exists is the current one, that is the 20-year VCC, 15-year PRR. And I do believe that, in my understanding of the VCC statute, is a court will determine whether a defendant qualifies as a VCC. Then it'll determine whether, under the circumstances, that it is appropriate to impose a VCC type sanction, which in this case would have been the 30-year mandatory up to 40 years in prison. Once the court makes that determination, it's not necessary for the protection of the public, even though he qualifies as VCC, he is not a VCC. So I believe that the sentence should be looked at as if VCC is not even in the sentence. And so his current sentence is 15 or 20 years as a PRR, which is the only authorized sentence for a PRR under the circumstances of 15. So based off the decision in Pope, also the decision in Hill, which is a 2020 decision out of the First District Court of Appeal, we look at the remedy and the type of situations. And in Hill, it was a situation where a judge imposed life in prison with a 25-year mandatory minimum. The court realized that the only way that it got to life in the first-degree felony case was by raising the minimum mandatory to a life minimum mandatory. It went ahead and tried to correct its intent to raise it to life with the life minimum mandatory. And the First District Court of Appeal said, no, you can't do that now. It's too late. What happened, even though your intent was to impose life, it's not authorized. We're not going to give you another opportunity to somehow get to life. We're going to go ahead and send it back under certain parameters with the discretion you would have had under the circumstances at that sentencing, and limit you between 30 to 25 year minimum, with a 30-year cap with a 25-year minimum mandatory. Sentence them in between that range. This case is no different than Pope, no different than Hill. The state shouldn't be given an opportunity to seek an enhancement that's not even noticed, that wasn't even requested at a de novo resentencing. So we're asking this court regarding the legal sentencing issue to remand for the 20-year BCC to be stricken and to keep the 15-year PRR sentence. Regarding the ineffective assistive counsel, if this court agrees with the argument, the remedy would be to have the state reoffer the 6.5-year sentence to taint the constitutional harm that was done by defense counsel. If there are no further questions, I'll rely on the briefs and ask the court to provide the remedies asked for.
All right. Thank you, counsel, for your arguments. And with that, we are